Today we're going to talk about Bryan Kohberger, the Idaho man who was arrested and accused of breaking into the home of University of Idaho college students and brutally murdering 4 of them. That man has now come to court and admitted that he did in fact kill the 4 college students, and he's entered a plea of guilty before an Idaho state court judge. What we're going to get into today is whether or not Bryan Kohberger should be spared and receive the life sentence that he has negotiated with the prosecution, or whether the law requires him to receive the death penalty, or at least for a jury or a judge to consider imposing the death penalty in this case. Stay tuned. Coming up next. Hi, I'm Judge Liz, and welcome to my channel. For those of you who are new here, you may recognize me as I'm the judge who presided over one of the most widely publicized death penalty cases in American history. I recently retired from the bench and went into private practice, where I'm a partner at my family's law firm, Conrad & Scherer in Fort Lauderdale. On this channel, I break down the legal stories that are making the headlines, the ones that you're most interested in, and I try to give you a point of view that you won't get anywhere else. So stay tuned, and thank you for joining me today. The first thing I want to give you some background on is the general law of the death penalty. Some of you may know, some of you may not, but here it is. There's 27 of the 50 states that currently have the death penalty as a possible punishment for murder in the first degree. Idaho is one of them. In fact, Idaho reinstated the death penalty in 1973, along with many other states. That was following a United States Supreme Court decision, finding it to be humane and constitutional as a possible punishment. Now, in Idaho, you can currently die or receive your death penalty sentence by either lethal injection, or recently they've also added death by firing squad to options that a defendant may choose if he or she is sentenced to death. One issue that many people are often confused about is people think that any person convicted of murder in the first degree can receive the death penalty, and that is not true. I used to try to explain this when I'm teaching students in college and high school even, that you can't get the death penalty unless you not only commit first-degree premeditated murder, and it is the worst of the worst. So the death penalty in every state and under the Constitution of the United States is reserved for the worst of the worst. Now you may be saying, Judge, murdering somebody and premeditating that murder, that's how can that not be enough? Well, it's just not. That's what the law says. So I'm going to give you an example. When I was a prosecutor, I prosecuted a young man. He was in his early 20s. He picked up a prostitute. During the course of their interaction in his vehicle, they got into an argument, and he took the butt of a gun and he pistol whipped her in the head until her head was completely sunken in. And when the police arrived, he then dumped her on the side of the road. And when the police arrived, they initially thought she had been shot at close range because her head had a huge hole in it, but it was actually from beating her with the butt of a gun. That case did not qualify for the death penalty because even though that sounds completely brutal, it was not considered the worst of the worst. The worst of the worst has to have what are called aggravating factors. And they're very similar in most states. And I'm going to read to you what these aggravating factors are in Idaho so that you know why Bryan Kohberger was being considered for the possibility of the death penalty in the first place. Under Idaho state law, there are 11 statutory aggravating factors, and the prosecution has to be able to prove at least one of the 11 aggravating factors in order for the defendant or the accused to qualify for the death penalty as a possible sentence. I'm not going to read all 11 to you now, but I'm going to read to you what would qualify Bryan Kohberger for the death penalty under Idaho law. At the time the murder was committed, the defendant also committed another murder. So we know he killed 4 people. He's admitted that now. Beyond a reasonable doubt, he's pled guilty. He's admitted that he's done it. So when he's murdering one person and then murdering another person, murdering a third and a fourth person, that is an aggravating factor. Basically, when you murder more than one person in the course of one criminal episode. So that's one aggravating factor. Another aggravating factor that he would qualify for is that the murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. Now, this heinous, atrocious, and cruel aggravating factor is also an aggravating factor in Florida. And what does that mean? It means that if you get mad at your husband or your wife and you go and get your gun and you're thinking about it and it's premeditated and I'm going to kill this person because I'm getting sick of I'm getting sick of them talking back, or I don't like the way they cook dinner, and you go grab your gun, that's premeditated because you're thinking about it, and you shoot him in the head, well, that is terrible. It is not considered heinous, atrocious, and cruel under the law. However, breaking into the home of 6 college students and brutally stabbing one after another, while 2 are lying in their beds scared for their lives. If you can imagine not only what the ones were thinking as he was stabbing number 1, 2, and 3, what number 4 was thinking, and while he's stabbing number 2, what number 3 and 4 are thinking, and so on and so forth. These victims had to be in a complete panic, utter horror. This is like the type of bad dream that you wake up from and you say, oh, thank God. I mean, this is heinous, atrocious, and cruel to its very core. The third aggravating factor is by the murder or circumstances surrounding its commission, the defendant exhibited utter disregard for human life. Okay? Going into a home and brutally murdering 4 of 6 of the occupants is an utter disregard for human life. He could have stopped himself after the first one. He could have had some type of remorse. He could have changed his mind. He could have abandoned his whole entire plan, but he didn't. He went in and he methodically killed these students who did nothing to him. In fact, who had never met him before, had no idea who he was. He went into their home while they slept and viciously and brutally murdered them one at a time. That is a prime example of an utter disregard for human life. The next aggravating factor that he would qualify for is that the murder was committed during the perpetration of a burglary. So we all know that he has pled guilty to, so I don't want to hear anyone saying, Judge, you should be saying alleged. I don't have to say alleged anymore because he has pled guilty to it. He has admitted it as part of his plea. He didn't plead no contest. He didn't plead guilty in my best interest. He said, I am guilty. I did these things. And he has admitted that he broke into that house. In other words, went into that house surreptitiously without the permission of the occupants for the purpose of committing the murder of those students. That is a burglary, and murders that are committed during the course or commission of a burglary is another aggravating factor that supports the death penalty. So in order for a person to qualify for the death penalty as a possible punishment, one aggravating factor of 11, there's 11 total available on the books. The reason that I did not read them to you is because some of them are like the killing of a police officer or the killing of an elected official. Those obviously would not apply in this case. I read only the most obvious applicable ones that would apply to the facts of this case. And in this case, there are 4 aggravating factors of 11 that apply, and you only need 1. Under state law, you need 1 in order for the person to qualify for the death penalty. Now that I've gone over all of this, the question is, why has the state, against the wishes of more than one victim's family member, in other words, there's 2 separate victims' families that have spoken out against this plea. They do not believe the defendant deserves life in prison. They believe that the defendant should be tried for this murder and that the jury should determine whether or not he should receive the death penalty. The death penalty is the law of the state of Idaho. We know, I've gone over the aggravating factors. We know that at least more than one of them apply. The family is for it. So why is the prosecution negotiating a deal behind the victims' families' backs that they are not in agreement with? Why does this happen, and is it allowed to happen? So many of you may be thinking, Judge, not everybody is pro-death penalty. And you would be absolutely right. And that is absolutely a person's right. That is a personal belief that different people can have. But let me tell you who can't be anti-death penalty. The prosecution in a state where the death penalty is a possible punishment. That person cannot be anti-death penalty. That office cannot be anti-death penalty. Let me give you an example. When I was a prosecutor, I worked in an office of probably 400 attorneys, okay? And there were different units. And there was a top prosecutor who was in charge of what we call the sexual battery unit. That was all sex crimes. And I once asked him, because the sort of the highest unit or the most elite unit in my office was considered the homicide trial unit, and they tried all of the capital cases. So I once asked the head of the sexual battery unit, why is it that you never went to homicide? Why is it you spent 25 years in the sexual battery unit? And he told me it's because I don't believe in the death penalty. Why is that important? Because up until very recently in Florida, you could not receive the death penalty for any sex crimes against a person. That law has since been changed, but that was just very recently. This gentleman has since retired. But the point being is he recognized that I don't support this one particular law in the state of Florida, and the unit that I would have to support it in order to be able to prosecute those cases is the homicide trial unit. So I am going to choose not to go to the homicide trial unit, even though it's the most elite unit, because I don't believe in the death penalty. I cannot argue for the death penalty. So this gentleman was recognizing his personal beliefs, but he was taking himself out of a situation where his personal beliefs would override the law of the state, which is Florida, where the death penalty is a punishment for murder in the first degree. That is the appropriate way to respond if you are somebody who's in a prosecutorial position, but you do not agree with the law in the state. Because like I said, the only person who cannot, it is not appropriate for them to not believe in the death penalty, is a prosecutor who is prosecuting first-degree murders or capital cases in a state in which the death penalty is the law of the state. Those people should not be in those positions if they do not believe in the imposition of the death penalty as a punishment. I'm sure it's obvious by now my feelings on this whole plea offer. To me, when a victim's family or multiple victims' families speak out and are against the offering of a life sentence in exchange for a plea of guilty and waiving the death penalty, if the victims' families are opposed to that and there's no legal reason that you have to waive it, in other words, there may be a case that would absolutely qualify for the death penalty, but there's not enough proof. There's just not enough evidence to convince a jury beyond and to the exclusion of a reasonable doubt that the defendant is guilty. Now, if I don't know all of the evidence in this case. I know what the defendant has pled guilty to. I don't know what the state was going to use to try to prove the allegations. So perhaps the state attorney thinks that the case is 50-50 and that there's a chance the jury could find the defendant not guilty of these murders. If that is the reasoning behind the prosecutor's decision, then I wholeheartedly support their decision. If there is a legal reason why you say, you know what, it's just not worth it, this man is dangerous, and 4 life sentences is better than him possibly walking free and hurting somebody else. If that is the reasoning, I wholeheartedly support it. But if that's the reasoning, you would think common sense would dictate that the prosecutor from Idaho would have called those families into their office ahead of time and explained to them, listen, I have to make this decision because legally speaking, I am not certain that we can prove this case beyond a reasonable doubt. Here are the legal pitfalls of our case. Here are the problems with our case. And I'm going to make the decision that it is in the best interest of the community members of the state of Idaho to offer this gentleman or this man, this defendant, I wouldn't call him a gentleman, this knife murderer, I'm going to offer him a life sentence because I can't risk that he be acquitted at trial. If that is the reasoning, then that is the sound reasoning, and that is within the discretion of the prosecution to make. Because ultimately, although a victim has rights under the Constitution, and in fact, specifically under the Idaho State Constitution, the victim has a right to be heard at every critical stage of the proceeding. And the victim has a right to give his or her point of view on how they feel about this particular plea offer. So, like I said, common sense would dictate that if there was a legal reason that this plea needed to be made, these victims would have been privy to that decision and would have been explained the reasoning behind the decision beforehand. 2 of these victims are saying that before it was announced to the public, these family members, they had never even heard of this. And their position was, Under no circumstances do we want this plea to be offered. We feel the death penalty is appropriate and the jury should get to determine whether or not to impose a sentence of death or a sentence of life. So I mentioned to you the Idaho Constitution, and this applies. You may be thinking, what's the Idaho Constitution? For those of you who are not aware, we have the United States Constitution that everybody knows about, but each state also has its own constitution. And Florida, where I live and where I presided over a death penalty case, has the same type of constitutional rights for victims of crimes. And I looked up the Idaho State Constitution, and according to that constitution, there's a Declaration of Rights, Section 22, Rights of Crime Victims. And it specifically says, the victim of a crime as defined by the statute has the following rights, specifically to be heard at all criminal justice proceedings, considering a plea of guilty and sentencing. What that means is the victims have an absolute right to be notified and to be heard. Now, in Florida, the way that we interpret that is that the victims would have a right to speak with before the state attorney or the prosecutor is going to make some type of plea offer. They would be called into the prosecutor's office, and the reasoning behind a plea offer would be discussed with the victim. And if there was not, in my office that was run by Michael J. Satz, who was the state attorney for 45 years, an incredible leader and human being, his way of thinking was, if there's not a legal reason for me to waive it and it otherwise qualifies, in other words, it has an aggravating factor and the victims are in support of it, then I'm going to let the jury decide, because he believed that was what was fair and what was appropriate. So let's take the case I presided over, the Parkland shooting case. There were 17 people killed. So unless and until, it was made very clear by the state attorney, Mike Satz, that unless and until all 17 victims' families agreed that a life sentence should be offered to the defendant, that there was no way he was going to make that kind of plea offer, and that he was going to put the case before a jury to decide whether the death penalty should be imposed. Why? Because he had a rock-solid case with plenty of evidence, 10 out of 10. There was video, there was surveillance, there were records, there were eyewitnesses, pretty much the whole thing was caught on video from start to finish. It was a slam dunk case for the prosecution, legally speaking, and Mr. Satz, the prosecutor, knew that. He also knew that there are 17 victims' families to consider, and to consider how they feel. And I have to say that this way of thinking is the way that I believe, because whether or not you are pro or against the death penalty, okay, most of us, thank God, have not been in a situation where our family members have been brutally murdered by another person. And I think for someone to sit sort of on the outside and look at it in a vacuum and decide whether or not somebody should receive the death penalty when they are not the one that is affected by the heinous, atrocious, and cruel acts of the defendant, to put aside the victim's feelings and how it has affected them and what they believe to be a just result, I think is unfair, and I think it's inappropriate. In the state of Florida, we had a prosecutor in Orlando in 2017 who declined to go forward and try to proceed and get the death penalty on 17 first-degree murder cases that otherwise qualified and had aggravating factors. Our then Governor Rick Scott removed her and found, if you can't follow the law and you have no other reason other than, I think her reasons were, oh, well, it's a waste of resources. But you know what? He said, that's not up to you. There are victims, family members that need to be considered. And you can't just say you think it's a waste of resources and it's not in the public's best interest. Although a prosecutor represents the state, in other words, the prosecution of the state of Florida represents the state of Florida and the people of the state of Florida, and the prosecution in the state of Idaho represents the people of the state of Idaho, victims under the state constitution have a right to be heard, and there is a reason for that. God forbid any one of us looking in from the outside, making a judgment on what sentence should be imposed, actually has to go through something like that. It's unspeakable. I have seen people who have lived through a family member being brutally murdered, and it's one of the most horrific things that a person can observe. It's one of the hardest things I've ever done in my entire life, is watching these family members come to court day after day and have to live through not only the court process, but the autopsy reports and the anniversary of the crime and the anniversary of their children's birthdays. I mean, it's horrible. And to say that a prosecutor would take away their desire to seek that a jury determine whether or not the death penalty is appropriate for whatever reasons and set their feelings aside, I can't accept that. You may agree, you may disagree, but that's my feeling, and that comes from my experience on the bench. Again, I believe not in favor, not opposed to the death penalty, but I believe in following the law, and I believe that if in your state the death penalty is the law of your state, and a defendant commits a crime that qualifies for the death penalty, that has aggravating factors that can be proven to a jury, and the victim's family members are in favor of the death penalty and believe the defendant should receive the death penalty, I believe following the law means following their wishes and putting it before a jury. I believe the prosecution in Idaho has a duty to put that issue before the jury and not negotiate the victims' families out of the equation. I don't think it's right. I don't think it's just. And I don't think that the judge should agree to that sentence. Now, he's accepted the plea. So he's already said he's accepted the plea. He has not imposed a sentence. I don't see him saying that he's not going to accept the sentence of life in prison, because I think when he accepted the plea of guilty, he would have had to say, I'm not making any promises whether or not I'm going to impose life or death. And I think then the defendant would have backed out of his guilty plea, and that would have forced the parties to go to trial and force the state or the prosecution to put the issue before a jury to decide. He did not do that. So I believe that he will accept the negotiated agreement and sentence the defendant to 4 consecutive life sentences. The only other possible scenario I could foresee is if the judge hears from the victims and hears, that they're completely distraught, that they were not notified, that they don't understand, they don't understand why this plea is being made, that they understand the risks of going to trial, but they're willing to take those risks in order for the jury to determine whether or not the defendant should be sentenced to the death penalty. If the judge hears all of those things, he could be persuaded to set aside the plea, to say, you know what, I've changed my mind. I'm not going to accept this plea. This case is going to go to trial. Again, that's a possible scenario. I don't see that happening here. But from what I know in this case, I don't believe this was a fair and just outcome. And again, I don't know everything. There could be things that I don't know. But I think the fact that 2 separate family members from 2 separate families have spoken up and said that they are completely against this person receiving a life sentence, completely against the jury considering the death penalty, I think that's unfair. I think it's unjust. I think it is not following the law. I think that just as Rick Scott set aside the prosecutor in Orlando, I think that the Idaho governor could set aside this prosecutor and find that another prosecutor needs to take over. Again, that's very unlikely. It doesn't happen that way, not very often. Most of the time, politicians are not willing to get into the middle of it. But again, think about those victims. They're the ones that should be driving the bus on this issue. You may agree, you may disagree. I'd love to hear from you. I'd love to read your comments below. Again, this is not a pro or anti-death penalty video. This is just a video about what I think is right, what I think it means to follow the law as a prosecutor and as a judge. But I would still love to hear your thoughts. Is there something I'm not considering? Is there a fact that I don't know about? Something that I left out? Leave me a comment down below. Let me know what you think. Let me know if you'd like to hear more on this subject. If there's something that I left out, something you like, you didn't like, I try to respond to most of the comments if I possibly can. Thank you for watching, and I hope to see you again soon.